Alright, ebusian for mamda mu na masi emfambre ye channel yiso. Medo bibiasi ediba ye channel yiso. Na masel say notification button ehun hia me ye pa obetene ne on. Say the updates bebe bia onso nsa be den e be ka no ahwe. Na bibia aye kama kama. Say the news e mu hwam na ye de bra mu. E brentima nyibre. Yenkotie ensem kakra ekoso.
He re-empaneled. We'll tell you who he empaneled. He has a right to do that. That's a right to do. He re-empaneled himself and other people. We'll tell you about that. We'll tell you about the argument that was made in court that was initially overruled. Godfrey Dame was surprised to see Justice Baffoe on the panel, and he raised an objection about it. Tonight, I've spoken to one important Supreme Court judge who's telling me that there's another reason why Justice Baffoe sat on the panel, that there could be another reason. The Supreme Court judge told me that tonight. I'll be sharing with you, of course. I told him that I'll be sharing with my audience tonight. He said it's fine. It's part of legal education, so I should share with my audience. The other reason why Justice Baffoe was there. And then we will also talk about how the two applications for live coverage were both denied by Justice Baffoe. Incidentally, one of the applications was from here. Good evening, Ghana. We wrote a letter to him wanting to continue with the live coverage that Justice Tokonu had started. You remember that all the cases of December 2024 came on live on television. So we are very used to that. When election petition 2013 was shown on television, we were all very excited, and it ended until election 2020 was also shown on television. But since the last 1 year and a half, Justice Tokonu has allowed the case of the three vacant seats in Parliament was on television. The case of the LGBT was on television. And there was a third one, I can't remember. I think that was also the vacant case or e-levy, something like that, was on television, where we saw, of course, Justice Tokonu arguing Tadeo. Sorry, all the videos that you see these days, it was from her administrative pen permitting live coverage, because in her own words, Justice Tokonu said she wanted Ghanaians to see that how the judiciary and the Supreme Court works, so that it's all demystified. It also helps us reporters so that we're able to report better, and it also puts some pressure on the lawyers. So when they come out of the room and they are having their argument, they know that we all saw it. So they are very careful on what to say and what not to say. We'll be discussing all that in great detail tonight, and we're going to start from here. Before then, permits me at 22 minutes past 10, I'll take a 5 minutes break. When communications, Felix Kwachofo, so he released a statement that President Mahama has received petitions against the Chief Justice, and in line with Article 146 and the provisions thereof, these petitions have been shipped to the Council of State, and that the Council of State were looking at it. Now, some lawyers became concerned that a fundamental legal process is being breached, a fundamental legal maxim, a fundamental principle that underpins the law of rights is being breached. It is the principle that says that you must hear other side. All the term pattern, they say you have to hear the other side on every matter before you come to a conclusion. That is why the scales of justice tilt. They don't tilt anyway. They are equal, because you have to hear the other side. Is one of the principles that underpins the scale. Okay. So they went to court through, one of them was a member of parliament, Mr. Asifo, the member of parliament for Tafo, and he went to court asking lawyer Godfrey Dame to file the processes for him. Godfrey Dame being the former attorney general, of course. So he filed these processes, and the court panel was constituted to hear the matter. Many legal observers were watching whether Justice Tokonu will empanel herself, because she had the right to do so. She has the technical power to do so. And this matter was about her. It was about her impeachment. So that if she empaneled herself, she has one vote her way. And there's no law against it, as it were. There's no technical law against it, as it were. So the panel came out as follows. Justice A.J. Frimpong, Justice Darko Asare, Supreme Court Justice Yao Jehu, Supreme Court Justice Henrietta Mensah-Bonsu, Professor of Law, and Supreme Court Justice Adibu Asiedu. These were the 5 lady and gentlemen who were empaneled by Justice Tokonu to hear the matter about whether or not the president, in transmitting the petition to the Council of State, has jumped one step. And the step he had jumped was indicating a kind of breach in bad faith, because it was important that Justice Tokonu got it. Now you will see in a letter that President Akufo-Addo wrote to the Council of State that the petition had come to him and he had forwarded it to the subject of the petition, which is what one always needs to do. So Justice Tokonu empaneled these judges to look at the application that had come before the court, which was directly impacting her continued role as Chief Justice. Sometime along the story, Justice Tokonu then wrote a letter to President Mahama indicating the same thing, that she is yet to receive the petitions, but she understands that these petitions have been forwarded to the Council of State. In response to the letter, President Mahama berated Justice Tokonu for leaking her petition to him, to the media, because President Mahama said he had also seen it in the media. He, however, responded to Justice Tokonu by forwarding the petitions to her and giving her 10 days to respond to the petition. It would appear at this stage that perhaps the matter before the court was moot, because at that time, the real matter before the court was what they called a violation of the Constitution by a breach of the rule of audie autem patent, which is here the other side, as it is said in Latin. However, after Justice Tokonu responded to the petition, word came round that the Council of State was being asked to consider whether or not a prima facie case has been established in the matter. If the Council of State were to consider that the prima facie case has actually been established, the process in Article 146 sort of kicks in. In the process kicking in, His Excellency the President is told in Article 146 that he may or may not suspend the Chief Justice. May suspend the Chief Justice. It then comes to the discretion of His Excellency the President, that in carrying out this discretion, he will be able to suspend the Chief Justice if he so desires. But he will be able to keep the Chief Justice in office whilst the processes of Article 146 continue. What is the next stage? The next stage is that a committee be set up to look into the matter. The membership of the committee is also determined by the provisions of the Constitution. So, the Council of State proceeded to look at the matter. One day we were there when the Council of State said that they have looked at the matter and they have established a prima facie decision. Lawyers were unhappy with the matter. And then they said that the President, not being a judicial officer, when he sees the word may, where he wants to exercise his discretion in a matter that is quasi-judicial, as this matter is, quasi-judicial just means that it has a semblance of a judicial matter, but it is not properly judicial because the President is not a judge of the Supreme Court. He's performing a role as of a judge, but it's quasi-judicial. So quasi-judicial, for instance, is that you work at Metro TV, and then they say you have done something wrong, that you have violated the code of ethics of the company. So they set up a committee, usually chaired by Paul Adom, and the secretary is somebody else, and everybody is there. Then that exercise of that disciplinary action against the Metro TV staff is what we call quasi-judicial, because you are going to take a rule of conduct and you are going to interpret whether those rules of conduct have been breached. In doing so, you are sort of performing a judicial function as a judge of sorts, but you are not a judge, and you are not a high court judge, you are not a court of appeal judge. So what you are doing, which the law allows you to do, is a quasi-judicial function. It was said that because the President is exercising a quasi-judicial function, he, the President, ought to publish regulations on how this function is exercised, because it's a discretion and it's a constitutional matter. People say that in the best interest of the practice, we need to know ahead of time with sufficient predictability that when you get into this space, the President will exercise his discretion to do A or B. It should not be in the dark, and it should not be open-ended, where we don't know where, how, on what basis, and with what intuition that the President will come to this conclusion. But if regulations are published, we will know that if your matter is this way, that way, this way, then the President will come to this conclusion in exercise of his discretion under Article 146 of the 1992 Constitution. So this was the state of affairs at the time. So the lawyers went back to court, now amending their application, filing a new process, and saying that the Council of State and the President's decision to find a prima facie without telling anybody how they did it, and the President proceeding to suspend the Lord Chief Justice, were unconstitutional. And so this panel was going to hear the matter. All right. So everybody was ready. Lawyers were ready. Judges were ready. Media was ready. The people of Ghana were ready. Showed up in court to hear the matter. What happened? Mr. Justice Adibu Asiedu was unwell. Also, it was reported. He was unwell on that day. Justice Adibu Asiedu here. He was unwell on that day. And the president of the court, Professor Henrietta Mensah Bonsu, told the lawyers, Dominic Ayini for the Attorney General and Godfrey Dame for the applicant, told them that Justice Adibu is not here. The Constitution requires that with an application to the Supreme Court, as has been the practice, a minimum of 5 people will sit. In fact, that's the barest minimum under the Constitution with which the Supreme Court can constitute itself, except where the Supreme Court, in those instances where one judge can sit as one judge to hear an appeal from one of the lower courts in specific circumstances, or where a Supreme Court judge is sitting as an additional High Court judge or somewhere. Wherever the Supreme Court sits, the minimum number that the Constitution has granted is 5. It can be 7, it can be 9, it can be 12, it can be 13, but the minimum is 5. Therefore, with a panel of 5, that Justice Adibu Asedu was unable to show up, the panel could not really sit. It will be illegal for the panel to sit. So the case was called off, that it will be adjourned until sometime in May 6th or so, which was today. Now, 2 days later, more drama happens. A letter emanates out of the presidency of the Council of State indicating the process of the Chief Justice's Article 146 petition, the committee. The committee that was set up by the president names Justice Adibu Asedu as one of the 2 Supreme Court judges which the Constitution mandates must sit on that committee. 2 of them, Justice Adibu Asedu and Justice Gabriel Poamai, were the 2 that His Excellency named to be on the panel, and then 3 other people who are not lawyers and they are not members of the Council of State. Those 3 have also been named. Tongue started wagging. Everybody was concerned that, Asedu was sitting on the case, he wasn't well, and now he's on the panel. Anyway. So it turned out that Justice Asedu cannot make it anymore on this panel. And people were wondering that here is Justice Asedu, who has already been empaneled to hear this matter, and now he has been selected to be on this one. What is going to happen? Is he going to come and recuse himself from this? What's going to happen? Nobody knew. In the meantime, the Chief Justice is suspended, and the senior most judge, Justice Paul Baffoe, takes position as the acting Chief Justice. Word gets round that Justice Baffoe on day 1 of work is making a lot of significant changes here and there. We hear all that. All those changes have been made. No, fair enough. Okay. Now, let's get into the meat. So, Justice Baffoe now has the right to do a new panel. What happens? Wait, let me go to... Yes. He takes out of the existing panel. Adibu Asedu, of course, is out. We know that because he's going to be on the panel for the committee that's going to listen to the Chief Justice in the substantive matter of the petitions against her. So he's out. And then Justice Baffoe also takes out Justice Dako Asare, who was originally empaneled, takes him out. And then he takes out Justice Eje Frimpong, who was originally empaneled. So these are the 3 judges that get out of the situation. 3 judges get out. And then 3 judges get in. Justice Leonie Kulendi, Justice Baffoe, the acting Chief Justice, and Justice Amadou Tanko, all are 3 who come into the matter. The biggest controversy about this was the arguments that were made by the former Attorney General in court today. Now, he was concerned that Justice Baffoe, being an acting Chief Justice, he said, is a direct beneficiary of this process. Therefore, Justice Baffoe should not add himself to the panel, even though he does have the administrative right to empanel. Now, the Supreme Court heard the matter, and all 5 judges of this morning, including the 3 here, agree that the Chief Justice can sit. So they overruled Godfrey Dame on that matter. I've heard Supreme Court judges giving several reasons why the court ruled this way. But then this evening when I spoke to another Supreme Court judge, he's telling me one thing, that there's another argument that I need to bring to the attention of my viewers tonight. Why Justice Baffoe can sit. He says that to say Justice Baffoe is a beneficiary of the process is not altogether wholesome and correct. Because Justice Baffoe has not been appointed the Chief Justice. He has not been told that he will be appointed Chief Justice. There's been no announcement that he will be appointed Chief Justice. The reason why he's there is because he is in an acting capacity on the basis that he's the senior most justice at the Supreme Court. So he's not been appointed Chief Justice. He's acting in an administrative capacity as the senior most justice of the Supreme Court. And therefore, he's able to sit on the panel. Because tomorrow, if the Justice Tokonu thing goes through and for whatever reason Justice Tokonu doesn't come back, the president can decide to appoint Amadou Tanko as a new Chief Justice. And Justice Baffoe will revert to his role as a senior most. the consistent and persistent Deputy Chief Justice is the senior most judge of the Supreme Court. So as a Deputy Chief Justice, he's only stepping in the role of the Chief Justice because there's an administrative issue that he has not been appointed the substantive Chief Justice. This is what the Supreme Court judge told me tonight, that must also form part of the information that I share with my viewers so that they can make their decision whether it was right or wrong. It was not technically wrong because he saw the court rule in that way, but the question is, was it morally right? Was it morally incorrect? It's up to you, viewers. Look at it and let's see what you think. But more interesting revelations. Now, it was these 3 judges who were added today that swayed the court away into a majority of 3. I'm not reading anything into that. 3 judges here who came in. Justice Yoni Kulendi, Justice Baffoe, and Justice Amadou Tanko were the 3 who ruled in favor, who ruled against the application, and therefore the application fails. The 2, Professor Henrietta Mensah Bonsu and Mr. Justice Jehu, ruled in favor of the application, that the application should succeed. Justice Baffoe sat on the panel as well. So this is the story from the Supreme Court today. At 7:30, they went to the court. They heard Justice Baffoe was sitting. A lot of conversations about whether he should sit or not. An application was filed. The application failed. But I'm telling you what another Supreme Court judge told me about what happened. But the other story is that, coincidentally, it was the 3 judges who came in this morning who delivered the majority opinion, which we are yet to read sometime in May, I think another week or so. I'm guessing that the majority opinion will be written by Justice Yoni Kulendi, and the minority opinion will be written by Professor Henrietta Mensah Bonsu. But there was a showdown in court. The case is not over. There was a real showdown in court. And I take the showdown straight away on the touch screen. Justice Kulendi says, in the case at hand, what will be the substantive constitutional breach in respect of the respondent's conduct? Justice Kulendi puts the question to Godfrey Dame, the former Attorney General. He says, Mr. Dame, let me ask you, in the case at hand, what will be the substantive constitutional breach in respect of the respondent's conduct? The respondent being the president, by the way. The respondent is the president. The applicant is Asifwa. The respondent is the president. Then Godfrey Dame says, my lord, the failure to give the Chief Justice notice. So Justice Kulendi says, what will be the substantive constitutional breach in respect of this? And it says it is the failure to give the Chief Justice notice. That's what Godfrey Dame says. Simplifies the matter. Then Justice Kulendi continues. It is a question of time as to when the notice be given. Show us anywhere in Article 146 where the time is set as to when the notice to the Chief Justice ought to be given, as such violation will be a manifest constitutional aberration. Justice Kulendi was piling pressure on Justice Godfrey Dame to demonstrate where is the constitutional breach. Show me the constitutional breach. Is it, what is the point? Article 146 says what? Does it say when, at what time? It doesn't say. That's Justice Kulendi's question. Let me read it again. It says, it is a question of time, comma, as to when the notice be given. Show us anywhere in Article 146 where the time is set as to when the notice to the Chief Justice ought to be given, as such violation will be a manifest constitutional aberration. Godfrey Dame says, the Constitution is silent on that, and that is the essence of the constitutional issues before this court. I like the banter. The judge says, show me where the thing is. The lawyer says, it is not there. That is why you are here. The purpose of the Constitution, the Supreme Court, is to give clarity to things that are either not in the law that ought to have been there, or things that lend themselves to 2 or 3 interpretations. That is the essence of the court. If there was a black and white situation, Article 146, we will not be here, my lord. We will not be here. We are here, and you, the law, your lordships, are empowered with experience and learning and teaching that can help us to be able to go through this process in a way that a constitutional court works. That was the banter between Justice Lord Kulendi and Godfrey Dame. But as if Professor Mensah Bonsu was listening to both of them, she then entered into the fray with Justice Sremsai in this way. She said, the right to be heard is a constitutional right, and Article 23 requires that administrative justice should respect this right. Address the court on this, Learned Attorney General. Address the court on this. So she makes a substantive statement and says, listen, the right to be heard is a constitutional right, and Article 23 requires that administrative justice should respect this right. Please address the court on this one. And then Justice Sremsai, the Deputy Attorney General, says, my lords, the right to be heard has been provided in the procedure outlined in Article 146. Hence, the issue is at what time the enjoyment of this right is to be respected. At what time the enjoyment of this right is to be respected. And then Professor Mensah Bonsu says, should the enjoyment of this right accrue after the respondent, the Chief Justice, has been tried in the court of public opinion? Sremsai says, my lords, I rest my case. So they are talking about rights. Professor Mensah Bonsu says, it is a right for everybody to have the right to be heard. Show me how this right should be enjoyed. He says Article 146 provides that the right can be enjoyed, but it doesn't say at what time the right should be enjoyed. You see, the president gets the petition, sends it to Council of State. The argument is that president gets a petition, send it first to the subject before the Council of State can have the petition and what the subject says, so that they can come to a conclusion of a prima facie. But you don't send to the Council of State only one side of the story and ask them to do a prima facie. This is the conversation going on. And they are saying that where, at which point? And Professor Mensah Bonsu is saying that, okay, if you're asking me at which point or that the Constitution is at which point, are you suggesting to me that it's okay for you to give the document to the person after you have tried the person in court of public opinion? That is to say, after everybody has seen the petition and is gone to Council of State, is it at that time that you are going to give the person the right to be heard? After the public has seen, after the Council of State has seen, after they may have prejudged the matter, after they may have made their opinion, is it at that time that you are going to show to the subject? This was a conversation between Professor Henrietta Mensah Bonsu, who was on the minority side, writing the minority opinion of 2, and Justice Sremsai, who is the Attorney General, Deputy Attorney General, and Deputy Minister for Justice. Justice Sremsai, in answer to the rhetorical question by Mensah Bonsu, said, my lords, I rest my case. Okay, so this is how it ended. I'll come to Professor Mills and, oh no, not this one yet.